Hello and welcome back. GovDoc News, no opinions, just facts and summaries of government documents. You do the rest. We are back with a Supreme Court order from October 10th, 2025 in the case Hunter Munson P. v. the United States. And here we are seeing a granting of certiorari by the Supreme Court, meaning they are agreeing to hear this case. So, let's get into the background. In February 2024, Munson P. Hunter III pled guilty to one count of aiding and abetting wire fraud. Now, wire fraud involves using electronic communications to carry out a scheme to defraud somebody, often for financial gain. As a part of the plea agreement with federal prosecutors, Hunter agreed to waive or give up most of his rights to appeal his conviction or sentence, a common feature in plea bargains to encourage quick resolutions. The judge in the case sentenced Hunter to 4 years and 3 months in prison, followed by 3 years of supervised release and over $235,000 in restitution to victims of the fraud. The judge also included a condition in the supervised release that Hunter could be involuntarily medicated if needed, which Hunter objected to, arguing it violated his constitutional rights. Also, an important point here that we need to know, during the sentencing, the judge actually explicitly told Hunter that he had the right to appeal his sentence, despite the waiver in the plea agreement, creating a potential conflict. So, in response, Hunter filed an appeal in March 2024 to the Fifth Circuit Court. Hunter argued that the involuntary medication condition was improper and violated his constitutional rights, also that the plea agreement's appeal waiver shouldn't block his challenge to this condition, especially since the judge advised him of his appeal rights. And on December 6, 2024, the Fifth Circuit dismissed that appeal, choosing to enforce the waiver in the plea agreement that barred Hunter from appealing. Then, Hunter petitioned the Supreme Court to hear his case, raising two main questions. One, whether appeal waivers in plea agreements are valid when they prevent challenges to unlawful or unconstitutional sentencing conditions like the involuntary medication order we see here. And two, whether a waiver can still apply if the sentencing judge explicitly tells the defendant they have the right to appeal, creating confusion or misleading the defendant. And here we are seeing the Supreme Court accepting to hear the case, leading to a review and an issuing of a full decision by June 2026. All right, time out. Keep your mind open. Do your own research. Form your own opinion. See you next time.